Greetings and welcome to Troutman Pepper's Patent Post-Grant podcast series. My name is Andy Zappia and I'm joined by my colleagues Mike Goldman and Megan O'Gara. We're doing something a little different in the podcast series this time because we've got a multi-part topic. We're going to do a series of 3 podcasts on this particular topic because we think it's interesting and it's a little complicated too. So luckily we have 2 real experts on the podcast to help us walk through it. The focus of this series of podcasts will be the use of reissue or reexamination procedures for amending claims as an alternative to the motion to amend option that's available in inter partes review proceedings or IPR proceedings or post-grant review proceedings. The 3 portions of this podcast are going to be, for this portion, part 1, we're just going to talk about reissue versus reexamination and the pros and cons of using one or the other in the context of a post-grant review proceeding. And then for parts 2 and 3, we're going to dive deeper into reissue, if that's the tool chosen. And then for part 3, we're going to look more closely at reexam, if that tool is chosen. But to start off and just to do some table setting on this, one question that often comes up is why are these procedures even considered in the context of post-grant review proceedings, especially because there is a motion to amend option as part of those proceedings. So Meg, I don't know if you want to comment on why these other procedures come up in this context.
Sure. I'm happy to lead us off here, and Mike can jump in with his expertise as he sees fit. This was highlighted in a 2019 notice from the USPTO, these 2 procedures and the use of these 2 existing procedures as a way to amend claims post-grant, a tool to use by patent owners that were faced with particularly an IPR challenge or a post-grant review challenge, because the motion to amend practice has proven so difficult to amend claims during those trials at the patent office. These reissue, reexam procedures are existing procedures. These weren't new from AIA. And so the patent office put out this notice clarifying the use of these and how they could be used in conjunction with an IPR proceeding.
I think the patent office in issuing this notice is continuing to feel some pressure to improve the amendment process in conjunction with post-grant proceedings because they have not been particularly successful so far. I think we have a situation where the board, the PTAB, does not really shown a great desire to want to deal with these things and has established procedures that make it difficult to be successful in achieving an amendment of claims. And in addition, of course, you're in an adversarial proceeding where not only is the entity within the patent office that's going to decide whether you can have these additional claims or these amendments, but you have an adversary that's telling them why they shouldn't allow those amendments. In contrast, to get rid of the adversary in a patent owner initiated reexamination or a reissue, you have an organization within the patent office that's different than the PTAB that's in the business of issuing patents if there's patentability established and in permitting amendments when appropriate. And of course, you don't have an adversary to get in the way of what the patent owner wants as far as amendments go. There's a lot to be said for why one should be looking at these, not diminished by the fact that the patent office is now in this notice actually suggesting that one look at those.
I assume that this comes up because if you're a patent owner in an IPR or PGR and you look at the arguments being made against your patent, you might think, well, I've got a better chance of keeping patentable claims by amending them somehow, right? I would think patent owners who are faced with that kind of challenge, that's when they start thinking about motion to amend, or is reissue better, or is reexamination better, if they feel like they need to make amendments. Is that when this arises?
I think that's right. I think that's when folks are really looking at these procedures is with amendments in mind. I think that's exactly right.
And I think it can also come up, and we'll get to this more when we talk about the particular mechanics. For some of these procedures, and maybe all of them, you can even look at them after you get a decision from the PTAB, right?
Absolutely. You can file a reissue application or request reexam before, during, or after that trial, after the final written decision, as long as you precede some of the cutoffs, the issuance of the trial certificate or the conclusion of any appeal.
I guess motion to amend, no, that you have to make during the actual procedure. But these other ones you can do late in the process, right?
Yeah, absolutely.
I was thinking before we get too much into the pros and cons, it might be helpful just to talk a little bit about the basics of what these procedures are for listeners who aren't as familiar or don't regularly practice in reissue or reexamination. Meg, maybe you could start out by just saying a little bit about what reissue is, the basics of how it works, and some of the things you think about when you're considering it.
Sure, absolutely. These are cases that we handle quite a bit, but a lot of folks aren't familiar with them. So I think it is important to go over the basics. Reissue of a patent is available by statute under Section 251, 35 USC 251. It can be used to correct a variety of errors in an issued patent. That includes correcting errors in the specification, correcting errors in inventorship, perfecting priority, a host of things. But important to our conversation here is really correcting errors in the claims. And those errors can be claiming more than you had a right to claim. So you'd be narrowing your claims, or less than you had a right to claim if you're within 2 years. And that would be broadening your claims. When you correct errors in the claims, I think it's important to point out that you're typically doing that via reissue practice when you don't have any other patent family members pending, when you don't have opportunity to present those narrower claims or those broader claims in the context of a continuation or a divisional application that might be pending within the same family as the patent at issue.
If you did, in fact, have the opportunity to avoid reissue and, in fact, go into a continuation or a divisional and present those new claims, generally speaking, we view that as the way to go rather than reissue. So, reissue is certainly beneficial, but not necessarily a preferred mode when you have that luxury of a pending case from the original family.
Absolutely.
When you're thinking about reissue, what are some of the rules and limitations and things like that that come up when you're thinking about maybe using that procedure?
Mike and I typically, when we counsel clients and what to think about when they're considering reissue, one of the very first things we address is that the duty of disclosure reattaches. It attaches for both when a reissue application is filed or when, in the context of reexamination, when a reexamination is ordered by the patent office. But it's something that should be front of mind for patent owners when they're considering these procedures, that they need to be prepared to deal with the duty of disclosure. And they really need to be considering that all the way through the process. But speaking more about amending the claims and the limitations around amending the claims, which is particular to our topic here, a reissue application that only seeks to narrow the claims is a much simpler case as far as limits than broadening the claims. So if you're narrowing the claims, you can really do that anytime during the life of the patent. And you can also do that to just introduce what we refer to as hedge claims or claims of intermediate scope, simply adding dependent claims. And that's important. We'll talk about that later today, but you can file that at any time to introduce those hedge claims. Broadening, Mike, if you want to take the lead on some of the limits around filing those broadening claims, because that's a really important consideration.
Yeah, pretty much when we have a patent that we're looking to reissue for any reason, perhaps because we think there's a validity issue, even though the focus might be on narrowing the claims to get around that problem, the question's always asked, do we have an opportunity to amend so that we're broader and get a win out of the process by perhaps broadening the claims in some other way that still would be valid over the prior art of concern, but would provide that opportunity to have a broader claim in some other respects. So we always ask for that. As long as it's within 2 years of issue that we're looking at reissue, that always should be on the table for anyone considering reissue for any reason.
And then the limitations around that, if you are within those 2 years, there are other considerations. Certainly, time is of the essence because you need to be looking at that 2 year window. And also, you need to be looking at whatever subject matter may have been surrendered during original prosecution because you can't amend your claims to recapture that surrendered subject matter. And we have a whole other podcast actually on that very topic. So I'm not going to dive too deep into that issue, but it is a big issue when it comes to broadening your claims and reissue.
I would think for a patent owner wanting to amend claims and looking at reissue, they might be a little concerned or scared by this concept of error. What is the notion of error, and should patent owners be worried about doing a reissue and, quote, admitting an error?
That can be a really difficult topic for patent owners. Not only you're correcting an error, you really need to say that you're correcting the error on the record. You need to provide documentation to the patent office describing that error. But I don't think it needs to be really that intimidating. You only need to cite at least one error that can form the basis of reissue under the statute. And that error can be as simple as failure to file additional hedge claims, failure to file additional claims of intermediate scope, those additional dependent claims. When we're talking about amending claims, that can be a really good avenue for those patent owners that are reluctant about an error statement on the record. Would you agree with that, Mike?
Yeah, I think hedge claiming is a great way out, except for the most anxious of patent holders about an admission of error, because really you're not saying anything is terribly wrong with the patent. You just like to have some more claims. And I think that should be comforting to people that are worried about it. Whereas if you're sitting there and saying that you claim too much, i.e., your claims are not valid, well, that doesn't look particularly appealing. So if that's your error, that's not something people want to do. Or even if you say you claim too little, well, that could have adverse effects in litigation, reflecting a worry about whether your existing claims are covering somebody's infringing activity or what you think is infringing activity. So I think the hedge claims in general is a good procedure to avoid risk in any context of admitting error.
We're going to talk later in this series about more detail about the mechanics, but let's say you get through the reissue process and you end up with allowable claims at the end. What happens then?
It's a really important question, especially, later in our conversation. You get a new patent. You get a reissue patent. It begins with a capital RE. It is a reissued patent and you surrender the original patent. The filing of the application itself, it's important, and this is an important topic of conversation when we counsel clients to talk about. The filing of the reissue application itself is just an offer to surrender the patent should a reissue patent actually go to issue. So that's a really important detail that patent holders need to be aware of.
Maybe let's talk about reexamination a little bit, because how is it different from reissue?
It is quite different. And just starting with the basic fact that a reissue is an application for reissue of a patent. It's a reissue application, whereas an ex parte reexamination, a patent owner requested reexamination, is not. It's a request. So it's not something that's just simply filed and begins prosecution. It is a request that then needs to be acted on by the central reexam unit to decide whether or not to order a reexamination or not. There's a couple other important differences. A reexamination can be requested by any person at any time during enforceability of the patent. Here, we're talking about the patent owner themselves being that any person. Right. They're going back to the patent office and requesting reexamination of their own patent. And like we said before, reexamination must be requested, and that request must be then granted by the patent office. That's different than the reissue application that's simply filed. A reexamination also has a different threshold for ordering that reexamination based on the request. The patent office has to find, and the patent owner in this context would need to present in their request something called a substantial new question of patentability. And that needs to be based on patents or printed publications. So it's quite limited, the basis for the substantial new question of patentability. There's a few things to unpack, but the key thing to remember is that the request has to identify those patents or printed publications that present a new non-cumulative teaching that was not previously considered by the USPTO and that calls into question the patentability of those claims. And that's what the request needs to set out and the patent office needs to decide.
So I guess in the context of, say, an IPR or PGR, a patent owner sees references that are raised, right? And they could go to reexamination and say these references raise a substantial new question of patentability and then use that mechanism to amend the claims to try to deal with those or other references?
Yes, that's it. And you can only narrow your claims in the context of reexam. That's another important difference between reexam and reissue. You can only narrow your claims in reexam.
Are there statistics out there about how often a reexam request is granted, such that the reexam starts?
It's a really high rate of order based on reexam requests. I think it's greater than 90%. And reexam is ordered after a reexam request is filed.
I guess that's a big difference from motions to amend in, say, an IPR BGR, because last I looked, success rates on those are under 30%.
Yeah, it's a significant difference there.
Big
But of
difference.
course, it should be kept in mind that the granting is just starting the show in a reexam. It's not really anything definitive. And what happens after granting is a lot of times, which is, I guess, good for the patent holder, a patent will emerge or a certificate confirming patentability will emerge from a re-exam. So it's different in that way as well. Presumably, if you've got a well-founded amendment and you can persuade the central re-exam unit that it is patentable, well, you're doing that ex parte and hopefully being successful.
It sounds like in re-exam, the patent office looks at anticipation or obviousness based on printed publications. In reissue, when they're trying to decide whether to reissue the patent, they're not limited. They can look at other stuff like 101 or 112. Is that right?
Yeah, absolutely. Reissue is a full scope of examination, as you would normally have in regular prosecution. That's another really key difference between reissue and reexam is based on patents or printed publications. It looks at novelty and non-obviousness to a limited extent. Section 112 compliance for any amendments you make, or 112 may come into play if you're looking at a potential prior art that you could swear behind, or there's an issue of priority. Let's
Mhm.
put it that way. 112 can
Yeah.
come into play when there's an issue of priority at play. But those are the primary bases for examination in re-exam context.
So I guess the same question I asked before, say you get through the re-examination, you have allowed claims, then what happens?
So in the context of a re-exam, you get a re-examination certificate at the end that basically proclaims the outcome and any amendments that have been made to the claims. But it is a certificate that's appended to the original patent. And that's a big difference between reissue and re-exam in this conversation. A reissue is a new patent, and a re-exam results in a certificate that is appended to the original patent.
Thanks for that real helpful summary of these procedures. So I guess we get back to our original topic. A patent owner's in an IPR or a PGR, and they don't like the motion to amend option, but they think they're in a better position altering the claims in some manner. You've got these two tools there. What are some of the pros and cons of them? And how do you figure out how to make the choice if you feel you have to go down this road?
Sure. I think it's probably helpful that we summarize a few of the differences between the two, and then we can talk through some of the advantages of those differences between reissue and reexam. We talked a little bit about you can just file a reissue application versus requesting a reexamination that then has to be acted on by the patent office and ordered or not. That's a difference. The threshold of a substantial new question of patentability in a reexamination versus the need for an error statement in a reissue application. A full examination in a reissue, which we can talk about in a little bit, but that might be a little bit scary on 112 for some folks.
Or 101 potentially, right?
Yeah, absolutely. Something that we didn't talk about yet, but you can't withdraw a reexamination once it's ordered. And a reissue application, you actually can abandon the reissue application at any point during prosecution. The original patent, as we talked about, is just an offer for surrender if a reissue actually issues. So you could actually abandon your reissue application and leave the original patent in place. In the context of claims, you can only narrow in re-exam, but you really have no ability to extend prosecution in a reexamination context the way you would in a reissue. In a reissue, you can file RCEs, you can file continuations or divisional reissue applications once you file that original reissue. But in a context of a reexam, there is no request for continued examination or RCE practice, and there's no continuation or divisional filings permitted. So the reexamination is really a standalone procedure for that patent.
Just listening to it, other than the scope of examination, it sounds like reissue has a lot of benefits. Let me know if you agree with that.
We talked a little bit about at the end of a reissue application, you get allowable subject matter, you actually get a new patent, a reissued patent versus a reexamination proceeding where you get a certificate of reexam that's really appended to the original patent. And the important issue there for a patent owner deciding what procedure they might want to use if they're weighing these two procedures is if there is a 1-year estoppel period at play under 315B in the IPR proceeding, where there's a limited opportunity for your adversary to file an IPR proceeding after being served a complaint alleging infringement, you have an opportunity to keep that door closed with a reexam.
I think there's a lot to be said for using reissue. I mean, in general, I think we like that procedure in any context as far as a post-grant procedure compared to re-exam. But, we have to remember that this notice from the patent office did present both choices as possibilities, and they talked about some of the pluses and minuses. So I think the fact that the notice does mention both suggests that consideration of reexamination is appropriate and that reexamination does have something to offer. Well, I think there are pros and cons, so maybe to get into a little more detail why reexam is something to consider in addition to reissue when you're trying to go outside the PTAB to have a motion to amend or to have an amendment considered. As we talked about, reissue can proceed if there's an error. And we've talked about how hedge claims may afford an opportunity to help a nervous patent holder raise an error that's not terribly consequential. On the other hand, reexamination doesn't look at error. There just has to be a substantial new question of patentability in order to get over the hump of having the request granted. That can be equally or even perhaps more inconsequential if you simply raise as a substantial new question of patentability whatever was raised in the, say it's an IPR, raised in the IPR against the original claims, and simply say that the IPR petition raises a substantial new question of patentability. So basically, your SNQ, as we call it, substantial new question of patentability, doesn't raise any new issue that's not already before the patent office.
Yeah, I think that's right, Mike. And I think, that may be more palatable since it's already been raised by your adversary during the IPR proceeding, for instance. I suppose it does depend on the timing of your filing of a re-exam because it won't be a substantial new question of patentability if the PTAB's already handed down its final written decision on that question. So if you're using, for instance, the same art or grounds presented in an IPR proceeding, you'd want to make sure your timing as a patent owner was right if you chose re-exam and you wanted to use those grounds for your SNQ to get your request granted.
Another thing we touched on, but just to kind of hammer home the issue, there is a difference in the scope of examination that takes place in re-exam versus reissue. And basically, a reexamination is going to look at the same kinds of things that would be looked at in an IPR, prior patent or print publication-based challenges to patentability. On the other hand, reissue can look at anything that normal examination would look at, including, as we've talked about, 101 and 112 issues. So if you as a patent holder have some concern about whether bringing it back into the patent office is going to reopen those issues, you might want to think real hard about using reissue.
That was great, Mike and Mag, and thanks to our listeners for listening to this podcast. We invite you to join us for our next two installments in this series where we'll dive deeper into reissue and reexamination in this context. In the meantime, Troutman Pepper's intellectual property team will continue helping its clients develop and implement global protection and commercialization strategies for intellectual property. For more information on how we can help you, please visit our website at troutman.com. You can also subscribe and listen to this and other podcasts in our series on post-grant procedures, including on Apple, Google, and Spotify. Thank you.
Copyright Troutman Pepper Hamilton Sanders, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman Pepper does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including, without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper. If you have any questions, please contact us at troutman.com.